welcome to Legally Speaking with me, Tarun Nangia. And today we discuss a very, very important subject that also impacts the economy of India in a sense. And it is a welcome move from the Supreme Court. A bench of Justice J.B. Pardiwala and Justice Mahadevan in the case of Mushir Alam versus State of Uttar Pradesh. Mushir Alam being accused in a Prevention of Corruption Act case, a financial crime case, that it does not make sense at all to arrest a person after the charge sheet has been filed. Uh, of course, it may seem that it wouldn't be happening, but it does happen. And that's why the Supreme Court has had to take cognizance and comment so seriously on this issue. Indeed, it's an appreciative measure that the Supreme Court has sent to the business community in India that there may be financial crimes, but that doesn't mean that after the charge sheet has been filed, one could be arrested. Also for the bureaucracy and others, of course, because financial crime cases, a lot of honest bureaucrats sometimes get embroiled into them for no reason. And if there was no reason to arrest them during the interrogation, then why after filing the charge sheet? But I think we have a panel of experts who know all this much better than me. Let me welcome Senior Advocate Vikas Pava, one of India's top criminal lawyers who practice at the Delhi High Court and the Supreme Court of India and other forums. Good to see you. Thank you for your time. I have with us Senior Advocate Abhimanyu Bhandari. Congratulations on your designation and thanks for joining on the program. I have with me Niharika Karanjawala Misra. She works with Karanjawala and Company, one of India's leading litigating law firms at the Supreme Court of India, with a special focus Niharika has is on the criminal practice. That's where she will bring in her expertise today on the show. At the outset, let me request Senior Advocate Vikas Pava to make the opening comment. Over to you, sir.
Thank you, Tarun, for having me today. This is a very important order which is passed by the Supreme Court. It's not that it's happening for the first time. Supreme Court has been saying, continuously since 2021. Justice Sanjay Kishan Kaul was the first one who pronounced at least 3 or 4 judgments on the same issue of arrest. So what is most important is that personal liberty of an individual in our country is a very important facet of the Constitution. And we have laws in place, we have Constitution in place, we have laws on arrest, but unfortunately they are not followed in the right perspective. We have presumption of innocence, which is in favor of an accused, that you can't, arrest an accused just like that. Section 41 of CRPC gives the reasons, under which the arrest can happen. So, but the order, coming back to the order which is pronounced by Justice Pardiwala, is that he says if the investigating officer consciously takes a call not to arrest an accused during the course of investigation, and the reasons can be, many. If the accused is joining investigation, he's available whenever he's called, and no recoveries are required to be made, no, custodial interrogation is required, and he takes a conscious call, and he files a charge sheet in the court, then where is the need for the court to take him into custody? Now, if you analyze the order passed by the Supreme Court today, is that the investigating officer in a case of Prevention of Corruption Act has filed charge sheet without arrest. So he thought that it's not appropriate for him to take the accused into custody, files a charge sheet in the court where cognizance is taken, and the court issues warrant against the accused. When warrants are issued, the accused has no option except to apply for anticipatory bail. He applied for anticipatory bail in the High Court. High Court also does not grant him anticipatory bail. So when High Court does not understand the law which is laid down by Supreme Court, in the case of Satyendra Kumar Antil in Siddharth versus State of UP, Siddharth case was also from UP. Amanpreet Singh versus CBI. These are all judgments which have laid down the law, and according to Article 41 of the Constitution, they all are bound by the law laid down by Supreme Court. But right or wrong, the Allahabad High Court did not grant relief. The accused came to Supreme Court, and Supreme Court says we don't appreciate this practice of the courts taking accused into custody, and reiterated the law which is laid down by the Supreme Court in 2021. So it is only reiteration of what has already been held. And we again welcome, another order we can again cite it and give it to the courts to say that please don't take accused into custody if the IO has consciously not arrested them. The courts do not have the power to even test the decision which is taken by the investigating officer of, not arresting an accused. So this order which is now passed, again, we have, we can just add it in the compilation which we file in the court. That one more order pronounced by Supreme Court, please don't arrest accused who have not been arrested by the investigating officer. Yes, of course, but if it doesn't, suppose the summons are issued by the court and he does not appear, then of course we have a procedure given in CRPC. The court can always issue warrant and call the accused to the court. But if accused is not arrested during investigation consciously, then of course the courts have no business to take the accused into custody again. That law is very clear now.
Thank you for that opening comment, Mr. Vikas Pava. We'll go to Senior Advocate Abhimanyu Bhandari for his opening comment on this order by Justice J.B. Pardiwala and Justice Mahadevan.
Sure. Thank you, Tarun. Tarun, this order is, of course, very welcome. But we need to once try and understand that why is this happening? We've had the great judgment of Antil, which Mr. Pava just mentioned right now in his opening remarks. Antil comes after the order in Siddharth versus UP, where Justice Kaul very categorically said that once charge sheet has been filed, there is no need to take anybody into custody. He should merely be able to file bail bonds and get bail. He doesn't even actually have to move even a bail application. He can file bail bonds and he can ask for his liberty and secure his liberty. But having said that, why are we in a situation where accused still feel the need to move an anticipatory bail application? Let's say a charge sheet is filed in the trial court. The investigating agency decided we are not going to arrest the accused. Accused should simply go and file bail bonds and get bail. But no, accused still goes and files an anticipatory bail. So the first question is, why does the accused do that? The accused does that, Tarun, is because notwithstanding Antil and Siddharth versus UP, accused or any person would be petrified because in many instances, Antil is not yet implemented. Now, Tarun, I don't know if you're aware, but in Antil, the court, after passing Antil, also was monitoring whether Antil has been implemented or not. And a couple of instances came up where the judgment of Antil was actually not being implemented by the trial court. So the Supreme Court, in one instance, I remember, and that it sent a judicial officer, 2 judicial officers for training because they were showing complete ignorance to the dicta of Antil. So that's the extent that the court went to. And if you look at Antil, which now has been applied in this new judgment that we are discussing today, and it's very welcome, in Antil, the Supreme Court notes that in our country, 2/3 of the prison population are under trials. Now, look, this person who comes to Supreme Court today, of course, gets bail, and it's very welcome. But this guy is was a government officer who gets his bail. But there are a large number of victims there who don't have the resources, who don't even know about where to get a lawyer from. And they're languishing, notwithstanding the observations of liberty, pro-liberty in Antil, which has now set the tone. So according to me, Tarun, it is high time that the Supreme Court not only stops at just saying that this is a peculiar situation that has arisen where people are being taken into custody even after an investigation, but I think it is high time that high courts start monitoring that the trial courts are implementing their judgment. And what is actually surprising is that the High Court doesn't grant this person anticipatory bail. He has to come all the way to Supreme Court for an anticipatory bail in a case where the investigating agency decides not to arrest him. So this case is quite a shocker because, after Antil, I would have thought that I would not have seen another case like that. But, it's surprising that we see that, and it's very welcoming that Supreme Court comes down heavily and says that it's a completely peculiar kind of circumstances and that it's a peculiar practice to take someone into custody after charge sheet has been filed.
Thank you for that opening comment. Indeed, it's a telling story that despite so many orders by the Supreme Court and stern warnings, accused are arrested even after the charge sheet is filed when they were never arrested even before. That is worrying, and that's why I think the Supreme Court had to reiterate, as Senior Advocate Vikas Pava said, that they reiterated with this order. I'll go to Niharika Karanjawala Misra. Now, Niharika, your law firm takes up a lot of these financial crime cases when you're dealing with a lot of these accused. You engage seniors to argue these matters. What has your experience been, and why this order by Justice J.B. Pardiwala and Justice Mahadevan is very important?
So, Tarun, thank you for your question. Like Vikas sir said, the biggest apprehension in the mind of an individual facing trial is the fear of arbitrary arrest. We've seen this in our cases as well. It is the apprehension that even though laws are put in place, trial courts are not liable to follow them. Like Vikas sir said, and like Abhimanyu rightly said, since 2021, these laws have been in place, these rules have been in place. We have the cases of Siddharth versus UP, we have the Antal case. Yet the trial courts, for some reason, in some states are going ahead and ignoring the diktat of the Supreme Court. So there is that fear resonant in people's minds that causes them to be very cautious in every aspect of life. We've often discussed how a more pro-liberty stance and a more pro-bail stance would be very helpful on the investment in business side in Indian industries as well. Now, when you remove arbitrariness from it, and when you assure people that yes, if the Supreme Court has stated a law, that law will be followed by trial courts throughout the land, that is when that fear begins to dissipate, and that is when more confidence comes into play in the entire system of justice. So it's a very, very welcome order from the court. It's unfortunate that the Honorable Supreme Court has had to reiterate this and that their diktats are not already being followed, but hopefully this will be the end to it, and hopefully the like Abhimanyu rightly said, I think the right step and a very positive step would be for high courts in the state, because high courts in the state have a great deal more to do with the trial courts in those states than the Supreme Court ever will. And as a result, since there is direct supervision, there is a greater propensity to follow the diktats of the high court and not ignore them. It would be great to see high courts in every state ensuring that the law of the land as set by the Supreme Court is actually being followed to the T.
Point well taken. I'll go to Senior Advocate Vikas Pava. Mr. Pava, what happens is, I'm talking of primarily the talk in the promoter community, the business community, and the bureaucracy. Many times, as an unintended consequence, their name gets mentioned in the FIR. They may be acquitted in the end, but there is always this risk of arrest. Many times, because the agency do not think it is fit to arrest them, these promoters and businessmen, bureaucrats are not arrested. But say in the state of UP or some other states, they find that there is a risk of arrest after the charge sheet is filed, and the trial court also does not sort of, deem it fit to say that the arrest is not necessary. Do you think for investment business to thrive in India, the Supreme Court, as in this case, should come down heavily on any such attempt at arrests across India? Because a businessman who will raise even say 400, 500 crores, 1,000 crores is putting risk capital. His appetite for risk greatly decreases when he can be arrested on the flimsiest grounds simply because he is accused number so and so in a complaint where eventually he may be acquitted also. Can you, with your experience, share why this is important and why businessmen are at risk and why this is in the interest of the Indian economy, that we should not just throw businessmen in jail?
Yeah, I think it's a very important aspect of, of the criminal justice system. One of the facets of criminal justice system is certainty in law, that the citizens of our, country should know what the law is, how the laws are implemented, and how the law will be executed. That is why we have Article 141 of the Constitution, which says that if the Supreme Court lays down the law, it has to be followed by all the courts in the country. This is one aspect. And if second aspect, just to answer your query, is that the arrests which are made in our country are also very, indiscriminate. There is no justification of the arrests which are being made. And there's a pick and choose policy, which we see. I think Abhimanyu and, Niharika, whoever is practicing on the criminal side, we see if there are 10 accused, only one is arrested. If there are multiple accused, the CEO of the company is arrested, and then a chartered accountant is arrested, or the chairman is arrested. Whenever we challenge that arrest in the court, very, very often the investigating officer are unable to respond to the queries of the court. And why have you arrested him? What is the justification? So there's this pick and choose policy, something which is causing a lot of trouble to the business community. That is because of uncertainty. If we know that there is a law, if we know that there is a law on arrest, which is accepted by all the courts, I don't think the community will have any problem. But when the businessman knows that every investigating officer will react differently to a situation and may arrest without giving any justification. And every day we fight in the courts, sometimes on the procedure, sometimes on the pick and choose policy, and sometimes the grounds of arrest are not being served on us. So for us, what is important is that we continuously tell the trial courts about what the law is and how the Honorable Supreme Court has interpreted the law on arrest and on remand and custody, and keep on fighting and keep on telling the court that
But
you
one quick comment, Mr.
follow
Pawar,
the
from you.
procedure.
I
Yeah.
want one quick comment. If Justice Padiwala, Justice Mahaden have to reiterate it, does it mean that Supreme Court orders are not followed by courts in the land? I mean, across?
Yes, of course. So what Abhimanyu has just said is that the until judgment came in 2021 and 2023 is the order passed by the Supreme Court bench where two of the judges were not following the dictum of Supreme Court. And the Honorable Supreme Court has directed the Allahabad High Court that please withdraw work from these courts. This happened in 2023, which was widely reported, in the newspaper. In spite of that, now in 2025, if the Allahabad High Court is not following the judgment of until, then the situation is very, very clear that they are not following the law. So every judge
You
yes.
made a very, very important point. I think judges should be sensitized, say at the Judicial Academy,
Yes.
that arresting one promoter can send shivers down the spine of 100 others,
Yes.
who may then sort of fear committing money to India. I'll go to senior
I
advocate.
will just add one thing. I remember one judgment passed by Justice Jaswant Singh in Punjab High Court with regard to GST violation, where the I think chief operating officer of the company was arrested. He dedicated 2 pages why the senior most officer of a company should not be arrested.
Is it?
But it has an impact on the day-to-day functioning of the company.
I'd like to read that. Thank you for pointing out.
Yes, I will send that judgment to you. And he realized this, that the senior most officers are being arrested, which has an impact on the business, which has an impact on the fact that there are hundreds and thousands of employees who are under him. He has to take decisions. He has to attend board meetings. So where is the need to put somebody as senior as the CEO or the chairman of the company behind bars? When do you know
In
that
fact,
the impact is so much on the business?
I remember, I think a court in UP had issued a warrant for the Samsung Global MD for some consumer complaint, if I'm not wrong. And that had created a furor in because, people thought it is just so simple that, you could go to a district court and simply get a warrant issued against,
Yes,
somebody who runs a global business empire sitting in South Korea. Is not even sitting here. An Indian subsidiary would have done something, and that's a fair point. I'll go to senior advocate Abhimanyu Bhandari. You worked earlier in London long years ago before you came to India. What differences do you see? Also, could you juxtapose that where we could be going wrong and what should we do so that unnecessarily promoters are not put through harassment?
Tarun, we can't even begin to compare the system and the bail jurisprudence in UK, Canada, Australia, and Commonwealth countries and compare it to the Indian system. We just can't even begin.
Okay.
Bail is a fundamental right there, and you get bail on the asking.
Okay.
Very rare circumstances don't get bail. There is a flight risk. One of the reasons why people are refused bail in our country is because a lot of time it's argued that there'll be a flight risk. In UK, they have what is called geotagging. They put that tag on your feet. So they ensure and they monitor that you don't run away. But having said that, bail is a complete right there. And, there is not much bail jurisprudence because everybody gets bail. So this is not even something which is discussed and debated so much. Now, in our country, while I think that the courts have been consistent, the Supreme Court has been consistent in saying that people should not be arrested after charge sheet has been filed. And I think this judgment is very welcome. So is Antil and so is Siddharth versus UP. I think we need to be also honest and say that our apex court has also been extremely inconsistent when it comes to general jurisprudence of bail. When I think contemporary history of India is written, and especially in regards to bail, I think the judgment which will stand out and remind us of pro-liberty will be Nikesh Tarachand, Justice Nariman's judgment, where Justice Nariman came down heavily and said that people are languishing on ED offences, on Companies Act offences for years because you have these twin conditions which are absolutely draconian. And that judgment was so welcome, Tarun, and I remember you did so many shows and it was a celebrated judgment. But what happened to that judgment? That judgment actually has been applied in Antil. Antil actually reflects the judgment. Justice Sundaresan cites that judgment with approval. But then what happened to that judgment? That judgment got overruled in a 3-judge bench judgment in Vijay Madan Lal. And I think, and therefore, that there is a degree of inconsistency when it comes to how the Supreme Court reacts on bail jurisprudence. I mean, we have to be mindful that we are a polyvocal court. The apex court is a polyvocal court. There's, as someone said, it's not one Supreme Court, there are 13 Supreme Courts, if 13 courts are sitting. But it's very important that judges now start taking a consistent approach. If you want to develop business in India, if you want businessmen to be secured, that they will get liberty, will be secured for them. Then whether it is a businessman or whether it is a ordinary citizen, everybody should be secure that they will get bail, because the fundamental principle of our jurisprudence is that you are innocent till you are proven guilty. So while this judgment is welcome, Tarun, I think there is a lot of work, especially that the Supreme Court has to do in coming out and telling us that, look, bail is a fundamental right. And I think that I hope that in the coming months and in the years, Supreme Court realizes that overruling Nikesh Tara Chand was misdirected, with all due respect and humility, and that we should reignite or get Nikesh Tara Chand to be good law. So I hope that that message comes sooner than later, because I think that will be a really good way to kind of emphasize that bail is a fundamental right which cannot be tempered with.
Point very well taken. I'll go to Advocate Niharika Karanjawala Misra from Karanjawala and Company for her intervention on what Senior Advocate Vikas Pava and Senior Advocate Abhimanyu Bhandari have spoken, the impact on the business environment. And because you front end with the clients, you deal with them, and then you engage seniors, you get a lot of first-hand feedback on what the client is thinking. Your analysis on that and your final comment on what Justice Pardiwala and Justice Mahadevan have done by passing such an order, and also sticking, in a sense, mentioning and writing and making strong comments on arrest after filing of charge sheet, or even the intent of the agency to arrest after filing of charge sheet. Over to you.
So as I said before, Tarun, I'm in complete agreement with Vikasa and Abhimanyu. It is a great hope that this will be the last time that this principle of bail needs to be reiterated by the Supreme Court, and it is a hope that it is going to be followed in the High Courts. Like I said, with clients, what I find most is the apprehension of the arbitrariness. When you as you can well understand, if you tell an individual, especially an individual who's facing a case, well, okay, so this is the law, but there is no guarantee that the law will actually be followed. It sets a shiver down anybody's spine, right? Because you aren't able to give them that comfort that people essentially seek from their lawyers, because what you're telling them is, well, I mean, this is what should happen, but in your case, we're not quite sure if it's going to happen. And I think Abhimanyu rightly said, a large majority of people facing jail sentences don't have access to law firms like ours, to lawyers like us. They don't even know how to go about getting access to legal aid or getting any legal recourse whatsoever. They wouldn't have the ability to move the court for anticipatory bail. They wouldn't have the wherewithal to go to the Supreme Court. So for people like that, the idea that your destiny hangs in the balance of such an arbitrary system is a truly frightening notion. And I think it would be enough to frighten people, CEOs from a business perspective. I think it would be enough to frighten the common man into mistrusting and distrusting the justice system, which is, I believe, the greatest fallout from arbitrary notions such as these. And ultimately, we have to remember that irrespective of whether it is someone behind a big business or whether it is an individual themselves, the deprivation of liberty when it is not required is a great wrong, not only to the individual involved, but to society at large as well. And the fact that this is still being argued back and forth in 2024 does a great disservice to our justice system. So what I hope for my clients, for people who are unable to come to me as well, I've always said this, that the enemy to progress in the legal field, and especially in the criminal field, is arbitrariness and is unsureness. And once there is certainty that the laws as they have as they are to be applied, are in fact being applied. It will move society and the justice system, the criminal system, well forward. So this, I feel, this is a very, very welcome judgment from Justice Pardiwala and Justice Mahadevan. And my hope is that this is the last time the Supreme Court will have to reiterate such a stand. And my hope is that the states and the trial courts do get in line with this and follow the verdict of the Supreme Court as it has been repeatedly stated.
Yeah, that is what is the hope. But I mean, in fact, as media, I think it's our duty that whenever the Supreme Court sticks its neck out in favor of liberty and sends a strong message, it should be highlighted.
Absolutely. And like Vikas sir said, there's no
One thing
guarantee
I would
for
like
it.
to highlight,
Yes.
one important aspect which we see in the court every day is lack of accountability. Suppose the investigating officer wrongly arrests someone, the courts are there to grant bail to the accused. And if a court doesn't grant bail, even in cases where bails are ought to be granted, then higher courts grant it. But no action is taken against the wrong arrest. No action is taken against the wrong orders which are being passed in the court. Now, as far as your show today is with regard to the business community, I have a very classic example, and it was one of the most unusual experiences I've had recently in an ED case. I'm not giving the name of the person. This person was arrested. He was from abroad. He used to come whenever he's called by the investigating agency. I'm just telling you this story to show the impact on his business. And he's quite a renowned businessman. He came all the way from abroad and he was coming regularly. Still, he's arrested. If he's arrested, his bail is granted after, say, about 4 to 5 months. When bail is granted, bail is challenged. When he seeks permission to travel abroad, permission is granted, but permission is challenged. When his discharge is argued, he is discharged from the entire case, his discharge is challenged in the higher court. And then the investigating agency comes up and says he should not be even permitted to travel. So this poor chap who's now exonerated from all legal proceedings, there is no case pending against him, can't travel abroad because the agency doesn't want him to travel. So see how the law is being misused for a businessman, and there is no respect for his business. The case is given too much of importance on the aspect that, yes, there is a crime which has been committed, although there is an acquittal or a discharge in his favor. But the aspect of the business, the livelihood, is not being considered by any court at all. That's a very important aspect of life. Right to livelihood, for even for an accused, is a very important facet. But nobody is considering that as a ground for grant of bail also. That he has a family to support, or he has a business to support, he has people, the employees, the workmen who are dependent on his liberty, that is not being considered. And that's not the ground for bail at all in our country. So this was one example of a case where I realized that the impact of the wrongful arrest or a wrongful implication on a businessman is so huge that we can't even imagine. See the damage which it does to the business community. If you keep somebody outside the business for, say, about 15 months or 2 years or 3 years because of the arrest, see the damage which is done to the entire industry as a whole. And Abhiman, absolutely right. Abroad, bail is a rule, where, of course, our law also says bail is a rule, but we hardly follow it.
Actually, you've made a passionate argument on this issue and highlighting the promoter's plight. I fear that once he's faced it, how many people he's going to tell this, and then they get scared to put money in India because they feel we may get, there is no way out. We'll waste 2 years in jails, and that will be a bigger problem. I think we should carry forward this discussion in another part. We are running out of time now, but it was indeed duties of all of us that if Justice Pardiwala and Justice Mahadevan has stuck their neck out and given such an order, sending a strong message, we highlight it and shout from the rooftops for all the lawyers, promoters, GCs to know that the Supreme Court is here for you. Supreme Court will send a strong message. I hope the lower courts, or as it is said, we can't call them lower courts, district courts, they take note. And in a sense, we don't see such kind of arrest after the charge sheet has been filed. I would like to thank Senior Advocate Vikas Pava, Senior Advocate Abhimanyu Bhandari, Niharika Karanjawala Misra from Karanjawala and Company. You made time to speak on such an important order by Justice Pardiwala and Mahadevan. It is for liberty that you have all stood up. I appreciate your time. Thank you for your time. Thank you for joining us. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.